The lease renewal notice was sitting on the kitchen counter when I got home, already signed by my husband. Removing my name from it, I didn't notice it at first. I was pulling off my boots in the entryway, the kind of January cold that follows you inside and lingers in your joints. My coat was still damp from the walk from the LRT station. I'd been in Edmonton for 3 days running a third-party audit for a mid-size oil services company that had been quietly misclassifying contractor payments for 2 years. I was tired in the specific way that comes from finding rot in places people were sure was clean. I set my bag down, I filled the kettle, and then I saw the paper on the counter. My name had been whited out, not crossed out, whited out, like I was a typo. Below it, in my husband's handwriting, primary tenant, Damon Kowalski. Authorized occupants, none. I stood there in my damp coat with the kettle starting to whine, and I read it 3 times. Not because I didn't understand, because some part of me needed to count the seconds between reading something and feeling it, like checking the distance to lightning. He came down the stairs about 4 minutes later, in the gray Henley he always wore on Sundays, holding his phone. He didn't startle when he saw me. That was the part I kept turning over afterward. He didn't startle. He'd known I'd be home. "I was going to call you," he said. "Were you?" "I've been thinking about this for a while." He sat down at the kitchen table, not across from me at the head of it, like a meeting. "We're not working, Sloan. I think you know that. My name is Sloan Mercers." At that point, I was 31 years old. I am a forensic accountant. I find money that people are trying to hide, and I find the people who hid it. I have testified in 3 provincial fraud cases and 1 federal one. I am, professionally speaking, the last person you want to deceive. Damon knew this. He'd met me at a conference. He'd bragged about it at dinner parties. My wife finds bodies in balance sheets, the way men brag about things they don't fully understand. He thought he knew what my job was. He didn't know what my job made me. "You whited out my name," I said. "The landlord needed the renewal by Friday. My name was on that lease for 4 years. And I'm the one who's been here for 4 years." He said it quietly. "The way people say things they've been rehearsing. You're in Calgary twice a month. You were in Halifax for 6 weeks last fall. This is my home, Sloan. I need stability." I looked at the lease on the counter. I looked at him. He had the expression of someone who expected to be argued with and had already decided that any argument I made would prove his point. I didn't argue. I went upstairs. I packed a bag. Laptop, hard drives, my grandmother's watch from the drawer, 3 days of clothes. I came back down and picked up my bag and my keys. "That's it," he said. "I'll get the rest later. Sloan, we should talk about this like adults." I looked at him one more time. "Get a lawyer," I said, and I left. The drive to my colleague Fiona's place took 40 minutes in the dark. Edmonton in January smells like exhaust and cold metal, and somewhere beneath it the faint mineral bite of the river. I know that smell the way I know the back of my own hand. I grew up 40 minutes north of the city, in a house my father built on 2 acres that had been in my mother's family since the 70s. I left for university at 18 and never went back to live there, but I always knew it was there. Some places you carry like a fact. Fiona poured tea and didn't ask many questions, which is why I've kept her as a friend for 11 years. She made up the pull-out couch. I lay in the dark with my laptop open because that's what I do when the world gets loud. I work. Work is the only thing that doesn't ask anything of me that I can't give. I ran Damon's financials. Not because I suspected anything yet, just because I am constitutionally incapable of sitting in the dark without understanding the shape of a thing. What I found in the first hour was ordinary. Joint checking account drained to $1,200. Credit card with a balance I didn't recognize, opened 6 months ago in his name only. What I found in the second hour was not ordinary. A condo, purchased 8 months ago, listed under Damon Kowalski and a name I didn't recognize, Tiffany Doust. 312 Jasper Avenue, Unit 904. He'd put $40,000 down. Our joint savings account had held $42,000 11 months ago. I closed the laptop. I lay in the dark for a long time. Not because I was hurt, though I was, in the efficient, sealed way that comes from expecting the worst of people and having it confirmed. but because I needed to understand exactly what he had done before I decided what to do about it. Here is what he had done. He had moved money from our joint account into an account I had no visibility on. He had purchased property with another person using that money. He had removed my name from our lease without my knowledge, creating a paper trail that made me appear to be a non-resident. And he had done it all while I was traveling for work, while I was functionally away, and therefore unable to notice. He thought he had timed it well. He didn't know that I notice everything. And that timing is a variable I account for professionally. In the morning, I called my lawyer. Her name is Miss Oduya. She is 62 years old, has silver locks and reading glasses on a beaded chain, and she has never once in my experience told me something I wanted to hear when what I needed to hear was something else. That is why I trust her. She listened to what I'd found. There was a long pause. The savings account transfer, she said carefully. When did it happen? March of last year. 11 months ago. And the condo purchase? April. Sloan. She said it the way a doctor says a name before difficult news. That transfer is marital asset dissipation. In Alberta, if he moved shared assets for the purpose of purchasing property with a third party during the marriage, that property may well be subject to equitable division. I know. You know, I'm a forensic accountant, Ms. Oduya. I know what asset dissipation is. I need to know what you can do with it. There was a shorter pause this time. I can do quite a bit with it, she said. I want to be clear about something, because people always ask later. I was not running a revenge scheme. I was not plotting. I was gathering facts, the way I always gather facts, calmly and completely, so that I could make decisions from a position of full information rather than from a position of shock and feeling. That is how I was trained. That is who I am. If what I gathered happened to amount to a very clear legal case that dismantled everything my husband thought he'd secured, that was the result of his choices, not my temperament. I spent the next 2 weeks at Fiona's and then at a furnished rental near the university. I kept working. I had a contract with a logistics firm in Calgary and a preliminary engagement with a healthcare administrator in Saskatoon who was worried about billing irregularities. I kept my hours, sent my invoices, met my deadlines. No one at work knew anything was happening. That's not suppression. That is professional discretion. What I did in the evenings was build a file. The $40,000 transfer was documented. Bank records, timestamps, transaction reference numbers. I cross-referenced it against the land title registration for the condo, which in Alberta is public record. Damon Kowalski and Tiffany Daoust, joint tenants. I pulled her publicly available profile. She was a dental hygienist, 34, Instagram public. There were photos going back 14 months. Several of them had Damon in the background, soft-focused but identifiable if you were looking for him. One was taken on a rooftop patio in what appeared to be the condo building on Jasper. It was posted 9 months ago, 3 months before our joint account was emptied. He hadn't been careful because he hadn't thought he needed to be. He'd filed his taxes jointly with me for 4 years and never once asked what I did with the information I received as part of that process. He thought forensic accountant meant I worked with numbers. He didn't understand that what I actually work with is the distance between what people say and what the records show. The thing about asset dissipation in a marriage is that the threshold is not complicated. You have to show that money existed, that it was shared, and that it was moved unilaterally for a purpose that benefited one spouse at the expense of the other. I had bank statements. I had the title transfer. I had the dates. I had frankly a very clean case. What I needed for Ms. Oduya to move on it was his financial disclosure, which in a contested divorce he would be required to file. I also needed him to stop assuming this was going to go the way he'd planned. That part required a phone call. He answered on the third ring, sounding slightly surprised, like he'd expected me to let things settle longer. Sloan. Hey. I've instructed my lawyer to serve you with divorce papers, I said. You'll receive them at the Jasper Avenue address since that appears to be your current residence. Tell Tiffany I said hello. Silence. The financial disclosure is going to be thorough, I continued. Miss Oduya is very good at this. I'd suggest being honest on yours, because the things I've already documented make dishonesty on that form significantly more consequential. You've been investigating me. I've been documenting what you did. Those are different things. You did the things. I just found them. He hung up. I put the phone down and went back to the logistics file I'd been working on. There was a discrepancy in their fuel card records from Q3 that was bothering me. I worked until 11 and slept better than I had in weeks. Ms. Oduya filed the petition in the second week of February. Damon retained a lawyer, a young guy from a downtown firm whose primary experience appeared to be in commercial real estate, which told me that Damon still didn't understand what he was dealing with. His financials disclosure arrived 3 weeks later. It was not complete. He had listed the condo. He had listed his RRSP. He had not listed the investment account he'd opened 18 months ago with a discount brokerage, the one I'd found by running his SIN through a credit inquiry I was entitled to request as his legal spouse. It had $63,000 in it. He had also not listed the consulting income he'd received from a former employer, 2 payments totaling $19,000 paid to a numbered company he'd registered in his mother's name. A numbered company. In his mother's name. I sat with that for a moment, not because it surprised me, because of what it meant. He had registered a company using his mother as a nominee director. He had routed income through it to keep it off his visible earnings. It was not a sophisticated structure. I have seen offshore trust arrangements spanning 4 jurisdictions designed to hide assets from Revenue Canada. This was a man who watched one YouTube video about incorporation and thought he was untouchable. But the mechanism, however clumsy, was real. Income paid to a numbered company and not disclosed on a matrimonial financial statement is, depending on the amount and the intent, a problem that extends beyond family court. I called Miss Oduya at 8 in the morning. "How confident are you," I said, "that the numbered company and the undisclosed investment account constitute deliberate non-disclosure? Given what you've provided me." Very a pause. "How confident are you?" "Certain." "Then we have 2 options." I could hear her clicking her pen, the way she does when she's thinking. "We can raise it in discovery and let him amend his disclosure, which is the standard path, or we can raise it with the court directly and let the judge decide whether it rises to contempt. Non-disclosure in Alberta family proceedings is taken seriously. I've seen it result in adverse inference against the non-disclosing party, meaning the court assumes the hidden assets are worth more than what was found, and divides accordingly. I'd like to raise it with the court directly." "I thought you might," she said, and I could hear the almost smile in her voice. "I'll need your documentation." I sent her everything that night. Every transaction record, every bank statement, the credit inquiry, the corporate registry search showing the numbered company with his mother listed as director registered 14 months ago. The 2 payment receipts I'd traced through the brokerage's own transaction confirmation emails, which had been sent to an address he'd used for years and which I had legitimate access to as his spouse on a shared Damon's lawyer apparently called Ms. Oduya 2 days after she filed the disclosure motion. She relayed the conversation to me with the professional neutrality of someone who has been doing this for 30 years. "He'd like to settle," she said. "Define settle." "He's offering you the contents of the joint checking account, which as you know is nearly empty, and he'd like to keep the condo and the investment account." I said nothing for a moment. "He's also suggesting, Ms. Oduya continued, that since you travel frequently for work and have significant independent income, the court would view you as not requiring support." "That's creative," I said. "It's also incorrect. Alberta's Matrimonial Property Act doesn't factor in future earning capacity when dividing existing marital assets. What matters is what was acquired during the marriage." "I know. What are our chances if we proceed to a hearing, with the non-disclosure documented the way it is?" Another pause. "Strong. The investment account alone, if the judge draws an adverse inference, could result in him being required to equalize at a rate that accounts for the hidden assets at a premium. Combined with the dissipation claim on the condo, the $40,000 from your joint savings. I would say your position is very strong. Then we proceed. She filed the motion for disclosure sanctions in March. The hearing was scheduled for the second week of April, a Tuesday, in a courtroom on the fourth floor of the Edmonton Law Courts building. I wore a gray blazer and flat shoes. I had testified in that building before. I knew where the good coffee was and how early you needed to arrive to get parking. Damon arrived with his lawyer. He was wearing a suit I didn't recognize, which meant he'd bought it recently. He looked the way people look when they're performing calm. Slightly too still, eyes moving to check if anyone was watching. He glanced at me once when he came in. I nodded the way I would nod at a supplier I was completing a transaction with. His lawyer had evidently spent the preceding 2 weeks preparing arguments about my earning capacity, the nature of the joint savings withdrawal. He was going to characterize it as a gift, and the registered company, which he planned to present as a legitimate tax planning structure. I knew this because Ms. Oduya had received the pre-hearing brief. The judge was a woman in her mid-50s with the particular focused patience of someone who has heard a great many creative characterizations of financial misconduct. She read through the disclosures. She reviewed the documented transactions. She asked Damon's lawyer 3 questions, each of which he answered in a way that required a longer follow-up. I sat at the table with my hands folded and said nothing until it was our turn. When Ms. Oduya laid out the timeline, joint savings, $40,000, March transfer, April condo purchase, nominee company registered 14 months ago, undisclosed investment account. The courtroom was very quiet, the kind of quiet that has a texture to it. The judge looked at Damon directly. Mr. Kowalski, did you disclose the investment account in your original financial statement? His lawyer started to speak. The judge held up a hand. Mr. Kowalski, I didn't think it was an oversight. And the numbered company. That was a tax planning measure. My accountant, was your accountant aware that you were named as the beneficial owner while your mother was listed as director? A pause. Yes, is your accountant prepared to testify to that? Longer pause. The judge made a note. I'm going to adjourn for 15 minutes, she said. Damon's lawyer spent those 15 minutes in the hallway with him. I got coffee from the machine near the elevators. Fiona had texted me good luck at 8 a.m., and I sent her back a thumbs up. I didn't feel nervous. I felt the way I feel at the end of a long audit when the numbers have stopped moving, and you can see exactly what they add up to. Steady. Clear. When we reconvened, his lawyer announced that his client wished to discuss settlement terms. The terms we agreed to, with the judge present, were not the ones Damon had proposed in February. The condo on Jasper Avenue was to be listed immediately, with net proceeds split equally after accounting for the $40,000 dissipation claim, meaning my share came off the top before any division. The investment account, all $63,000, was to be equalized. The numbered company was to be dissolved, with the income that had flowed through it assessed as marital income for the relevant period. Damon's lawyer tried twice more to introduce my earning capacity. The judge declined twice. Damon signed at 2:17 in the afternoon. He didn't look at me. I looked at him, not out of anger. Out of the same professional habit I have when I close an audit. Checking that all the columns are accounted for, that nothing is missing, that the thing is finished. It was finished. The condo sold in May. It took 11 days on the market. Edmonton's spring market is reliable if you price correctly, and we priced it correctly. My share of the proceeds, after the dissipation adjustment, came to just under $90,000. I put 30 of it into a GIC. I put 40 into the investment account I'd had since I was 26, the one Damon had never asked about because he'd assumed, as people often do, that because I was good at finding other people's money, I must not have very much of my own. I used the remainder as a down payment on a small house in Glenora, 2 blocks from the River Valley trails, with a second bedroom I converted into an office. It's quiet there. I like it quiet. There are things I didn't do. I didn't call his mother, though I thought about it, not out of cruelty, but because I genuinely wanted to understand how much she'd known. I decided it didn't matter. I didn't post anything. I didn't tell the story at parties. Fiona knew, and Ms. Oduya knew, and my own accountant knew, and that was sufficient. What I did do on the last day of May was sit in my new backyard on a cheap folding chair with a cup of coffee and my laptop. The lilac bush along the back fence was blooming, the way lilacs do in Edmonton, short and overwhelming and over before you've finished noticing. I had a new contract starting Monday, a file involving procurement irregularities in a municipal infrastructure project. I was looking forward to it. I opened my contacts, scrolled to D, deleted him. No explanation, no last message to let him know I'd thought of one. The only things I needed him to understand were already in the court record, signed and dated and filed in a building downtown. My grandmother used to say that the best thing you can do after someone underestimates you is let the paperwork speak. She was a bookkeeper for 40 years. She meant it literally. So do I. Drop a comment and tell me where you're listening from. I want to know how far this one travels.